Hi, my name is Robert Turnage, and today I'll be facilitating this presentation, providing an overview of our agenda and introducing our keynote speakers. So first, for an overview of today's agenda, we'll start by telling you a bit about Tangible to provide you the context around what we do, why we do it, and how today's presentation fits into the bigger picture of our goal, which is to meet our clients' needs and to keep our team up to speed on best practices so that they can deliver consistently high quality results. Then we'll provide you with a high-level overview of the topic of today's discussion, the Master Professional Services Agreement, followed by a deep dive into common topics in MPSAs. We'll conclude with some final takeaways, including covering some commonly asked questions that you might have. So now let's take a closer look at today's speakers. We are very fortunate to have two highly skilled, sought after, experienced, and accomplished attorneys leading us through today's presentation. Robert Reynolds is founder and CEO of Tangible. He was previously a partner at multiple Am Law 100 law firms, including Alston & Bird and Safeart, where he was CEO of Technology Innovation. After decades as a highly recognized, high-stakes corporate attorney, his creative instincts led him to start something new, a company that aims to accelerate legal throughput and facilitate delivery, while also ushering in a new era of legal pricing models and spend management. His academic pedigree, extensive experience in business and law, and many awards speak for themselves. We could go on for hours about Robert's accomplishments, but suffice it to say that we are very fortunate to have him and his expertise guiding our discussion today. Alex O'Sullivan-Pierce is an attorney at Tangible and is also our Director of Legal Operations, a very business-focused attorney with an experience across a broad array of industries, including finance, athletic apparel, and technology industries. His accomplishments in the legal world, combined with his unique background as an educator, have quickly made him a key leader and innovator on the Tangible team. Having spent over 5 years as outside counsel with a focus on technology transactions, he's also an expert in the realm of sourcing and procurement. Again, we could spend hours discussing his many accomplishments, but suffice it to say that we are very fortunate to have his unique insights and experience contributing to our discussion today. Now, Robert Reynolds will provide us an overview of Tangible and our distinguished T3 model. So Robert, you want to take it over?
Yes, thank you, Robert. I really appreciate the great introduction and the review of our agenda for today. This slide talks about what Tangible is and what we do. We focus on big portfolios of high volume transactions for corporate infrastructure. So that would be domains like sourcing, real estate, sales, HR, retail disputes, and so forth. Our point of view is that to handle those portfolios well, you've really got to bring 3 core competencies. The first of those is a workflow platform that allows you to track tens of thousands, if not hundreds of thousands of transactions a year in each of those domains. Secondly, you've got to have application suites that automate the delivery of legal capability for those domains when appropriate, both for the legal function inside the large enterprise and also for the business functions that are served by the legal function. And then lastly, you have to have domain support packages, which is legal professionals, lawyers, and others delivering legal capability for processing those transactions, as well as the engineering capability to further customize the workflow platform and the application suites. Today we will talk about one of the most common transactions inside the sourcing portfolio, the Master Professional Services Agreement. Some of you may recognize that agreement as, or hear that agreement described as an MSA for Master Services Agreement, a consulting agreement, a contractor agreement, an independent contractor agreement, but they're all the same thing. It is an agreement that is used for the engagement of professional service capability to deliver output such as software code, architecture, blueprints, business models and so forth. The agreement will generally have a number of common terms in it that you can see listed here. And the purpose is to provide a legal framework for those terms so that you don't need to renegotiate them for every project with the same provider in the future. That agreement, the Master Professional Services Agreement, defines the client service provider's mutual responsibilities, and it allocates risk between the client service provider, as we'll discuss in greater detail as Alex and I get into some of the common topics in the Master Professional Services Agreement. We will adopt the perspective of the enterprise side of that transaction as a large company buying professional services for that sophisticated kind of deliverable, the software development code, creative services, and so forth. If you were instead representing a vendor providing those services, they would deal with the very same topics with perhaps in some cases a slightly different perspective. In many cases, the vendor in the large enterprise will have the same point of view on many of the topics. We will touch upon in this presentation those places where they might have a slightly different point of view and talk about strategies for closing the gap.
So thank you, Robert Turnage, for the great introduction, and thank you, Robert Reynolds, for the setup and giving us an overview of our presentation today on the Master Professional Services Agreement, and particularly for orienting us on the fact that we are looking at the MPSA through the lens of the buy side. Most of the guidance and best practices we share today will be oriented towards representing a buyer of professional services. As Robert explained, the Master Professional Services Agreement is a broad-ranging, overarching agreement that contains many different provisions, including the ones listed here on the right side of the screen. I'd like to remind everybody now that the compendium source to this presentation itself and the PowerPoint deck, which you see on your screen, is a template Master Professional Services Agreement that is available for download on the Tangible site, on our Tangible platform. And so before we move to the next slide, I'll just remind folks that the aim of today's presentation and the flow will follow that will follow the order of that template agreement that is available on the Tangible portal. And what Robert and I will be doing is kind of walking through the most commonly discussed topics and the most commonly negotiated portions of the MPSA itself. So, we'll touch on affiliate ordering, IP allocation, the always popular limitation of liability and indemnity, and even touch on some data security questions as well, as those are certainly the most commonly negotiated topics in an MPSA. The closely related topic is so speaking of the template and the purpose of a Master Professional Services Agreement, before we embark on using an MPSA, we should first make sure that we are using the correct template and that we are matching that template to the type of services that the vendor provides. Common uses of the MPSA, as Robert already mentioned, will be for vendors that provide consulting services, accounting, legal, other common professional services, anything in the design field, graphic design, web design, product design, and then, as Robert also mentioned, especially any kind of web or application development. These are good fits for the MPSA. Conversely, you should make sure that the vendor is not actually a provider of SaaS services, or is not a software company that's licensing out their software, because this will not be a good fit for the MPSA template. You should be using a different template to start as a starting point. That we won't discuss the important points of those agreements today. We will have future sessions on that Tangible will produce on those other types of agreement. So the last note here is that Google is your friend, which means that you should feel free to research the vendor and see if you can figure out just by searching online what their actual service is, so to make sure you're using the right template and getting off on the right foot when you're drafting your MPSA.
So the jumping off point for thinking about the MPSA and the work order and how you want to develop a drafting strategy for constructing those documents is the general framework of the MPSA and how you engage services underneath the MPSA. Generally speaking, the Master Professional Services Agreement will include both the master agreement itself as well as work orders underneath that master agreement. Master agreement will have the bulk of the commercial and legal terms for the general relationship. The SOWs or work orders underneath the master agreement will have the specific commercial terms applicable to a particular engagement, the deliverables, the pricing, the timeline, and any additional obligations of both client and provider that are specific to a particular engagement. The MPSAs are often evergreen, meaning they don't terminate by their terms, although either party will have the right to terminate them under specific conditions. And as I mentioned, the MPSA contains the bulk of the legal terms and conditions and the commercial terms. The work orders are for the particular engagement, they're generally fixed term, and they contain, as I mentioned, project-specific terms. The MPSA will generally include one or more work order templates to be used in documenting particular engagements. You'll see those templates range from straight T&E, time and expense engagements, where you're just asking the vendor to deliver certain resources to help with a particular project, to fixed price engagements where the vendor is charged with providing particular deliverables at a particular price. And then finally, on some occasions, the more complex and more sophisticated managed service engagements where the vendor is taking on some part of a business function for the client and will be charged with performing that business function for a period of time under usually service level agreements and other commitments as to the quality of the service.
So the very first paragraph of most MPSAs, and certainly our template MPSA that we are referencing today, is called the preamble. And in the preamble, you generally see an introduction of the parties that are entering into the contract and an agreement effective date. And this is an important area to focus on, because it's a highly visible area of the contract to our business clients. And so when drafting a preamble, please make sure to focus on correctly identifying each party's legal name. Obviously, some parties will transact business or they'll hold themselves out there on names that are slightly different than their exact legal entity name that's registered with a on this the Secretary of State website of their state of incorporation. But in the MPSA preamble, you'll need to make sure that you're stating those the precise, correct legal name of each entity. Also ensure that we should ensure that the effective date of the MPSA is prior to the start date of any of the proposed services. Sometimes contracting timelines will change during the course of representation. So you want to make sure that the final date on that MPSA is always prior to when the services actually start, so that all the terms of that MPSA can adequately cover the work that the vendor actually does for your buyer client. The last third focus here in the preamble is to take care to be consistent in using any defined terms. So in the preamble and actually throughout the entire agreement, it's important to focus on on how you're defining terms. If you are defining the buyer as a capital C customer or capital P purchaser, make sure you're using that term consistently throughout. The same goes for the vendor. If you're defining them as a capital V vendor, capital C contractor, make sure that that's consistent throughout the entire agreement. Oftentimes when we're copying and pasting or using templates, it's easy to get crossed up on defined terms, but please make sure that those are aligned before proceeding. The last note here is one that Robert Reynolds can certainly attest to, is that although all these notes in the preamble might seem, kind of common sense or elementary, it's highly common to find mistakes in this section, and so we urge folks to be focused and make sure that we catch these easy errors before they happen, and certainly before our business clients catch them for us.
So as another structural point here, it is customary for the MPSA to authorize ordering by affiliates underneath the MPSA. That's really very important for contracting efficiency. Most companies, even small companies, will have a subsidiary or other affiliated company. Rather than negotiating a new MPSA with the same vendor for each of those affiliates, the common practice is to have the vendor and the customer agree that all affiliates can order underneath the MPSA. It is interesting and important to focus on the definition of affiliate as you set up that ordering authority. Generally speaking, the common definition of affiliate is companies that are under common control with or control or are controlled by another company. But sometimes you will see, in particular circumstances, the definition of affiliate for this purpose expanded to allow contractors, consultants, and even employees of the customer or its affiliated companies to place orders underneath the MPSA. So think about that as you set up the definition of affiliate. But generally speaking, the MPSA should almost always authorize ordering by affiliates of the enterprise of the customer, and that's the takeaway from this slide.
The next topic we'll discuss is are those terms that relate to contractors' rates and the rate card as presented in the MPSA. So the key concept here is that rate cards provide a framework for future rates. And in many cases, it will be advantageous for a buyer to have the vendor of professional services include a rate card in the MPSA, because having the rate card in the framework agreement will hold the vendor to a particular pricing structure for as long as the MPSA is valid. So that will provide consistency and guarantee of prices for years in the future, and it can cover multiple engagements between the buyer and the vendor. Now, before the template MSA that we offer for this CLE presentation does include a space for rate cards, but it's important to remember that a rate card might not be reasonable or necessary for every MPSA. And this is an issue that you should raise with your business client to determine whether or not this agreement is one that should hold the vendor to pricing for years in the future. Sometimes if a vendor is a new or emerging vendor where their product or service offering is rapidly evolving, the vendors will understandably not want to lock themselves into any kind of pricing scheme. But other established vendors won't mind providing a rate card, and having that rate card will not only ensure consistent rates for your buyer client, but it will also speed up the contracting process for subsequent work orders that are entered into under the MPSA. So this is one of many or several issues and topics that will make sense to just discuss with your buyer client to make sure you're addressing properly in the MPSA, given the nature of the vendor's service. A closely related topic to contractor rates is payment terms. And payment terms are a commonly negotiated provision in an MPSA because they dictate how quickly your buyer client must pay the vendor for the services that are entered into under work orders under the MPSA. And vendors, unsurprisingly, are generally seeking faster or shorter payment terms. What we commonly see in our practice is anything from 30 to 90 days, with the 30 or 60 days being the most common. Just as with the rate card topic, this is one that you should visit with your business client to discuss, what is reasonable or possible for your client to agree to, given the finance and payment and purchase order processing systems that your client might have set up in their company. So for instance, you might have a vendor ask for 30-day payment processing, 30-day payment terms, but your buyer client will not be able to accommodate because they have a standard of net 60-day payment terms that are set up in their systems. It's also possible that your buyer client might be flexible on the issue. So check and confirm that with your business client to make sure that you're being flexible when possible, but that you're aligning with your buyer client's systems.
The next topic we're going to talk about is one of those really key issues under the MPSA, and that is the allocation of ownership rights in the deliverables provided by the consultant. The starting point for that analysis is, what business is a vendor in? Are they principally in the business of providing professional services and creating products under client specifications? Or instead, do they have their own technology, like software or a SaaS platform? And are they, in that case, being engaged to do enhancements or customizations of the platform? Reaching a conclusion about the principal business that the vendor is in will be incredibly helpful to appropriate allocation of ownership rights in the deliverables. The vendors that are in the business of providing professional services, and that is how they generate most of their revenue, will, generally speaking, be very open to and expect that the customer will want to own the deliverables provided by the vendor under the MPSA various engagements. By contrast, the vendors that are principally in the business of licensing software or marketing a SaaS platform will feel very strongly that they want to retain ownership rights in any customizations to that platform that are done under an engagement in the MPSA. And generally speaking, that's okay, so long as the vendor does provide the customer with a broad license to that development product that allows them to use that development product in a way that is expected by the customer. Sometimes in the latter case, where the vendor will end up with ownership rights, but license back the deliverables to the customer, you will see the customer ask the vendor for a particular head start or other protected period in their use of the development products, particularly when the vendor is in a highly competitive space. Let's say in the beverage space where the vendor has, the customer's got real secret sauce that they want implemented in the SaaS platform, or say financial processing software. They may not, in that case, feel comfortable that the vendor should turn around and have the immediate right to provide those customizations to other competitors in the industry. And you'll often see the customer ask for and the vendor be receptive to constraints around the ability of the vendor to at least immediately market those deliverables. A closely related topic is open source software. As you probably know, the open source software is a community-based and community source, crowdsourced software program. And if we could go back to the open source slide, it's probably helpful to help people understand what we're talking about here. But in any event, open source is a crowdsourced software repository, and it is customary or at least often done to have open source software pulled into development product, both by the customer and by the provider, when that strategy can accelerate and make less costly the development work. In other words, why reinvent the wheel when there's a good open source answer to a particular part of the functionality that the vendor needs to provide? When that happens, it is important to know that that crowdsourced software that represents open source is the subject of, can be the subject, and often will be, generally will be, the subject of any number of traditional license structures. And it's important to understand what that license structure is and to make sure that your customer is comfortable with that license structure. The key point there is that the customers that are engaging the vendor to provide internal software generally will be much more comfortable with the license constraints of the open source software than when that open source software is being introduced into a commercial product. And it's important to the customer that they have no constraints on their ability to commercialize that product. The other point with open source is that some of the open source licenses require some sort of reciprocity to license back functionality that incorporates the open source software. So you want to be careful about that. We'll have a separate session that really examines open source software, those licenses, and the key considerations around the incorporation of open source software in development product in detail. But for our purposes today, know that the MPSA should deal with the open source concern and provide guardrails around the vendor's ability to introduce open source software into the development product, and to require notification when the vendor does do that as permitted under the MPSA.
The next topic we'll be discussing is publicity. And in an MPSA, a grant or restriction of publicity rights relates to the vendor's use of your buyer client's name, logo, or trademarks for the vendor's own promotional purposes. So as you've heard us say several times before, we're working from the perspective of a buyer, and our template agreement is oriented from a buy side perspective. So you'll notice in our template agreement, we start from the assumption of no publicity, which says that the vendor cannot use our company, our buyer customers' company name, logo, or trademark for the vendor's internal or external promotional purposes. Conversely, if you were working from a vendor template MPSA, you would probably see a provision that starts from the assumption that the vendor is allowed to use the buyer company's name on some kind of their promotional materials, whether it's a client list or even in their advertising. So as with many other topics in this presentation, this is one that you'll want to review closely with your business clients so that you understand that company's stance on publicity and whether they are willing to let their vendor partners use their names and logos for publicity. Some purchasers might allow that their vendor companies to do that. And if so, you'll want to craft a provision in the MPSA that requires the vendor to obtain permission, written permission from the buyer company before using the name or logo for their promotional purposes. A special drafting note: when you are crafting a publicity provision, you should take specific care to require that any permission for publicity should be given by somebody from the purchaser's organization that has the authority to give that permission. So you might consider language such as permission from an executive with the title of director or higher, or just something that specifically states that not any employee of a purchaser company can give away publicity rights. Just think if you are representing a large buyer company with hundreds or thousands of employees, you wouldn't want to set up a provision that allowed any one of those employees around the globe to grant a vendor publicity rights. So once again, if a vendor is requesting publicity rights, check with your business client, see where your customer, where your client comes out on this issue, and make sure that the terms of the MPSA line up accordingly. So quick and important administrative note, if you are in a jurisdiction that requires a CLE confirmation code, the certification code for this presentation is tangible_MPSA. Thanks.
The next topic we'll take up is data security. This topic deals with the compliance with the data regulatory regimes in Europe, in the various states of the United States, as well as some of the federal data regulatory frameworks here in the US, as well as other data frameworks around the world. The key to compliance with those data frameworks is to understand first, what kind of data, if any, will the customer share with the vendor? It might seem at first glance that in a development engagement, that the vendor should not have access to any purchaser data. It turns out, however, that it is fairly common for the vendor to need access to the purchaser data to run through development product, to test development product, to ensure the quality of the development product. And for that purpose, will receive fairly high levels of customer data as they process that data. So you need to understand what will the vendor have access to, and secondly, what kind of data is that? Is it simply commercial data, which is likely to be still very important to the customer, or is it the kind of personal data that really gives rise to the far more rigorous obligations under most of the data regulatory frameworks? For many customers, it will largely be irrelevant whether it's commercial data or personal data, because they'll still have a data protection framework that requires a series of covenants to protect that data. You'll also need to know what regulatory frameworks are applicable, which has got to do with, where is the data sourced from? Is it EU-based data, for example, or Australian data, or California data? And that's going to tell you a lot about what regulatory framework is applicable to this particular engagement. Once you know that, you'll know what your obligations are, and you'll know how to comply with that obligation. Our template anticipates that we may need a data protection security agreement under many circumstances, when the sensitivity of the data or the applicable regulatory regime triggers requirements for an array of covenants that are better placed in an attachment to the agreement. And that's generally speaking the way that we handle it when we do encounter that requirement. The next topic we'll talk about in the next couple of slides is risk allocation. And risk allocation starts with the limitation of liability. It is very customary, traditional, for both vendor and customer to expect to receive the protection of a liability limitation in these MPSAs. Generally speaking, that liability limitation will be structured as a multiple of fees paid during a certain period of time under the MPSA. The period of time that frames the limitation of liability is generally no less than 6 months, well, customarily 12 months, and no longer than 18 and sometimes 24 months. South of 12 months, north of 18 months is unusual, but you do see it under the right circumstances. As a companion piece to the limitation of liability, you both vendor and customer expect to see carve-outs associated with particularly challenging events like a data breach, gross negligence by one party or the other, or other special circumstances that just should not be fairly the subject of a limitation of liability, and one party or the other will need to assume full responsibility for whatever that event is that will not be covered. Generally speaking, those carve-outs work more to the customer's advantage than the vendor's advantage, because the customer just has fewer performance obligations that the vendor does, and therefore less opportunity to participate in an event that should be the subject of the carve-out. But nevertheless, you see the carve-outs work both in favor of the customer and in favor of the vendor under most liability limitations. Once you've got the liability limitation sorted out, usually it resolves pretty easily. The next piece that you've got to worry about is the indemnity for third-party claims. That's a standard part of the MPSA. And what that essentially says is, look, if I do something that results in a third-party claim against you, I will protect you from that claim. And vice versa, if you, the vendor, do something that gives rise to a third-party claim, you'll protect me. Again, as with the limitation of liability, it is customary for there to be carve-outs from the indemnity for particularly unusual events that should not be the subject of an indemnity. Another component of the risk allocation framework are the reps and warranties. Generally speaking, the reps and warranties require the vendor to stand behind products or other deliverables that they provide underneath the MPSA. The warranties will include performance warranties. In other words, I'm providing software code. The software code works and it works well. It will include non-infringement warranties, which is to say, in developing this work product, I didn't step on anybody else's rights. That is particularly important for copyright and trade secret infringement. They can also be important for patent infringement, although that's a more challenging topic. You'll see title, you'll see code quality, and you'll also see customarily warranties against Trojan horses or other backdoors into the development product presented by the vendor, at least when the vendor is developing software. Occasionally under these agreements, the vendor will provide hardware when the hardware is a very small piece of the transaction and it's just more efficient from a contracting perspective to put it underneath the MPSA. And in that case, you will also expect to get a set of warranties on hardware provided by the vendor underneath the MPSA, including firmware that runs that hardware. Now, the firmware pretty much runs the world. You will see vendors often ask for the customer to make warranties reciprocal to the governance warranties made by the vendor. And that's usually an appropriate ask on the part of the vendor, and that has both parties then warranting that their company is in good standing, properly incorporated, and doing the things they need to do to just run the business.
The next topic is exclusivity, and you'll notice that many agreements, and in particular our template master professional services agreement, contain exclusivity terms that prohibit a vendor from simultaneously working with your buyer client and competitors that are in the same industry as your buyer client. The concern here is, of course, that the vendor will have access to confidential information relating to your buyer client's competitive advantage within their industry. And your client won't want that information being shared with other competitors' companies by virtue of having a vendor work both with your company and also with the competitors. Now, just as we discussed for the rate card topic, this is a topic that you should consider and discuss with your business client to determine whether it's reasonable or necessary to require exclusivity of a vendor. Our template MPSA starts with a very strict exclusivity obligation for the vendor. It says that the vendor, cannot work with a specific list of other companies that our client has deemed to be within competitors within their same industry. But such a restriction might not be appropriate for every vendor. To use an extreme example, if a vendor is providing landscaping or janitorial services, it's probably okay to allow that vendor to perform those services at competitors, as no confidential or sensitive information, will be transferred. Obviously, if on the other end of the spectrum, if a vendor is providing very sensitive custom development services, we'll want to make sure that the appropriate exclusivity provisions remain intact. Understandably, vendors are not always willing to agree to a blanket exclusivity provision. So we experience a lot of negotiation and pushback on these provisions. And one way to relax the strict requirement that we start from and to negotiate a middle ground with a vendor is to require that vendor not to simultaneously deploy the same resources on your client's projects as they do to a competitor company's projects. And that will allow the vendor to keep their customer base open while complying with a limited exclusivity obligation that should protect your client's concern of having confidential knowledge transfer. And the other element that you can introduce to relax the requirement is make it time bound, to say that a vendor cannot deploy same resources to your client's project into a competitor project within 30, 60, or 90 days after any particular project concludes. And that's a way to mitigate, negotiate, and find a middle ground there. Finally, before we leave this topic, it's important to remember that this key concept, that confidentiality and non-disclosure obligations exist independently of exclusivity. So in this MPSA and in most MPSA frameworks, there'll be separate obligations for a vendor to maintain the confidentiality of sensitive information. And even if they are allowed to work with competitors of your buyer client, they won't be allowed to share that information. So this is why we can sometimes relax exclusivity if we're careful to maintain a very strict confidentiality provision, as we'll be kind of covering the same concern with both provisions. Next topic, shifting gears a little bit, our term and termination. As Robert mentioned at the outset of our presentation, master professional services agreement and our template specifically is drafted with an evergreen term, meaning that it will stay in effect until it's terminated by either party. Conversely, specific work orders that are entered into under the MPSA have limited and defined terms. So when you draft or negotiate termination provisions in an MPSA, you should take care to define the difference between termination provisions that relate to the master professional services agreement itself and those that relate to work orders or SOWs under the master professional services agreement. The key here for many professional services engagements is that you want to maintain the right for your buyer client to terminate any work order without notice or cause, and without receiving any penalties or early termination fees. And that's commonly known as a termination for convenience. So our template MPSA is set up with a clear right to terminate for convenience. And when negotiating these provisions, you'll want to take care and look out for vendors trying to insert other terms or otherwise block the right for your buyer company to terminate for convenience. So you want to make sure to kick out or reject any additional terms that, excuse me, that amount to early termination fees or any other kind of penalties, whether those are attempting to be inserted in the Master Professional Services Agreement itself or any work order.
Thank you, Alex. A closely related topic to the term and termination concept that Alex just addressed is what happens at the end of the engagement. Is our customer going to need additional support from the vendor to transition the package of services provided by the vendor either back to the company on the one hand, sometimes called insourcing, or to another provider, sometimes called resourcing. In many of these engagements, especially development engagements, the transition services required from the vendor that's being terminated will be light. They need to provide the code base and other development product to the new provider, whether it's the company or another vendor, and maybe some guidance on code structure or that sort of stuff. Occasionally, however, as Alex and I have discussed in this presentation, an MPSA will be used to do a managed service relationship where the vendor has taken over some part of a business function for the customer. When that happens, you may need a lot of transition help from the vendor being terminated to get that package of services effectively moved over to a new provider or allow the company to effectively insource that package of services. In either case, however, it's incredibly helpful to define the transition services that you might need and to go ahead and do the commercial terms that will be applicable to those services so that both parties have reasonable expectations about what those transition services will cost, how long they will be provided, and what precisely it is the vendor will be expected to do. Now, it is also true that the MPSA can be used across such a broad range of service engagements that looking for transition support may not be necessary with many of those engagements, depending on what that vendor is doing. If the vendor is being engaged to do a special purpose project and successfully completes that project and the engagement comes to an end, no real need for transition services in many cases. So it's important to ask to understand the nature of the engagement and to think a bit about what kind of transition help we're going to need from the vendor when the engagement comes to an end.
So speaking of coming to an end, if you're following along in our template agreement, the companion piece to this presentation, you'll see that we've reached the end of the main body of the agreement and that we're now into the exhibit section. And just as we were careful to note that you should pay close attention to the preamble at the top of the agreement, the same note applies to the exhibit section. Many times lawyers are very careful to meticulously draft and negotiate the body of an agreement. And when it comes to the exhibit section, focus sort of fades for one reason or another, thinking that we're out of the main body of the agreement and the exhibits are somehow less important. However, Robert and I can tell you that the exhibits are in fact where many of the very important and client-specific policies and terms are contained. So should go without saying, but you'll want to pay very close attention to the exhibits. The slide here lays out a number of exhibits that you will commonly see in an MPSA and do see in our template MPSA. And I'll quickly walk through and discuss each type of exhibit, some of which we've already touched on before during the course of this presentation. So the first is a work order template, which is a blank form of a work order that would be entered into under the MPSA. As a housekeeping, storage, put away, administrative note, sometimes the exhibit work order is filled in as an initial work order under the agreement. So it'll actually contain details of the first engagement. It'll be a work order 1 attached as exhibit A, for instance. But in our template agreement, the work order contained in the exhibit is a blank work order and should remain a blank work order. And the initial work order 1 would be a standalone agreement. The second type of exhibit that you'll commonly see is a rate card. And we discussed that at the top of the presentation. This will be a list of the fees that a vendor will charge your buyer client under work orders for professional services during the term of the MPSA. Containing a rate card as an exhibit is useful mechanically because it allows you to update the rate card if the vendor's fees go up in subsequent years. You know, it'll allow you to easily amend the MPSA and swap in a new rate card. The third exhibit that you'll see in our MPSA template is the data privacy and security terms. Robert discussed these in detail already. The drafting and mechanical note for this exhibit is to make sure that you are using the correct flavor or form of data security exhibit that your client assigns to a transaction based on the data profile at issue. Many clients have maybe 1, 2, or 3 versions of a data security exhibit that they use for different types of vendors who have different access to different levels and different amounts of data. Make sure you're taking the appropriate steps to use the correct form for the particular vendor and transaction at issue. Fourth exhibit type is the change order template, very similar to the work order template. It's a blank order form that shows and contains the requirements for amending any work order under the MPSA. And just as the work order should remain blank, so should this change order template. It's just there to show how you would do this if you need to in the future. Next, we have an anti-terrorism and anti-corruption policy. Large buyer companies generally have, a 1-page or 1-paragraph policy that their vendors must comply with to ensure that they are, operating in accordance with international anti-bribery and anti-terrorism statutes. Those you should make sure to be using the most up-to-date version of your client's policy if they have one. And generally, this is not, highly negotiated by a vendor. They're willing to comply with those regulatory frameworks. The next exhibit type, as we're down to the second row on our slide here, is a customer competitor list. This relates to the exclusivity provision that we discussed earlier. So if you are listing out a specific number of companies that you consider your buyer clients competitors, that the vendor should not simultaneously engage with those companies under a exclusivity provision, they would be listed out in that customer competitor list. Next exhibit type is insurance requirements. These are also, generally very client specific, and they'll, check with your client to make sure you're using the correct and current insurance limits. Generally, the insurance requirements are flexible depending on what the vendor does and what kind of data they handle from your buyer client. So make sure if a vendor asks to lower any requirements, generally there's room to do that. But you need to have a firm understanding of what the vendor does for your client, what the risk associated is, and what kind of data they handle. Next exhibit up is the background check policy, particularly for professional services vendors who are offering resources that will work on site at a buyer's client's facilities. You'll want to make sure that the vendor is performing adequate background checks, and those terms can be contained in that exhibit. Second to last here on our list is a special billing and invoicing programs. If your buyer company has special requirements or programs to pay its vendors that might apply to the vendor entering into this MPSA, you'll contain the terms there. And finally, there's a gifts policy, which relates to the vendor providing, inappropriate gifts to decision makers at the buyer company in order to win business, and other kind of similar kickback relationships, which are prohibited. And so the terms of your client's gift policy could be outlined in that exhibit.
So we wanted to highlight what Alex and I believe to be the key takeaways from this session, if we've done our jobs well here. And there are really three. Number one, note that the MPSA provides a legal framework for engaging professional services. The master agreement serves as the umbrella agreement that contains most of the commercial and legal terms that are applicable to the general relationship as a whole. And specific engagements are handled by work orders that are entered into under the terms of the MPSA. Secondly, use the session topics. We suggest that you use the session topics as a checklist when reviewing the MPSA to make sure that you have addressed appropriately, if it requires addressing, but at least considered appropriately the topics we've talked about here today, as well as the other terms that are in the template MPSA that we provide in conjunction with this session. And then lastly, know that the MPSA and the master agreement in particular is intended to set up for the entire relationship the mutual responsibilities of client service provider and the appropriate risk allocation for the relationship.
So thanks, Robert, and to everyone listening out there. We hope you've enjoyed the main body of our presentation. Our next and final segment is we've queued up here 3 commonly asked questions that we've seen arise from our MPSA presentation. So Robert, I'll read off the questions and you can provide the answers.
Okay, thank you.
Great. So first up is, what are the vital points of most MPSAs?
That's a great question, Alex, and thank you. What's important to understand about MPSAs is in 99% of the cases, the terms, although they require attention and proper treatment, aren't going to really surface as a point once the engagement is contracted for. But what will surface are 3 really important business points that are critical to the client. And it's important to get this right. Most of the rest is going to be invisible to the client, but what they're going to pay a lot of attention to is, have they got the right to get out of the relationship? What are their payment terms? Are they consistent with client policy? And lastly, has a vendor introduced any terms into usually the work order that are inconsistent with either the MPSA or client policy or the client's business expectations? So what you got to get right, exit rights, payment terms, and vendor terms.
Excellent. Next question up is, what is the right way to think about ownership of IP between a vendor and purchaser?
So we talked about this at length with the ownership of IP rights, but we emphasize it here because this is a place where vendor and client can get a little stuck, and it can be time consuming unless we as lawyers help guide both parties to the right result. And we emphasize here the right way to think about it, at least in our experience, is what business is the vendor in? Are they predominantly a development shop, or do they provide technology? And once you know that question, you'll know, what rights are critically important to the customer to secure. And generally speaking, the customer is going to get comfortable with the idea that the vendor owns customizations to vendor technology, but that the customer, and conversely, the vendor can get comfortable that the customer should own output provided by a development shop. And again, we note that because this often can be a time-consuming discussion that can be greatly accelerated by just thinking about it in this framework.
Great. And the last question up is, what if a vendor says your MPSA is too long? And I'll actually take the answer to this one. And that is that you should consult with your business client and consider the business context of the proposed transaction to see if the vendor might have a point. What you should not do is kind of stubbornly or dogmatically just adhere to something because it's in the template. The template that we've provided as a companion to this MPSA is drafted intentionally to be over inclusive. So not every term might actually apply to every vendor, and you should be nimble and confident in removing terms that don't apply so that you can reach closure with a vendor who's making that argument. Of course, the caveat there is to always make sure to stick to your guns and maintain clear exit rights, and payment terms, and not allow the vendor kind of to insert their MSA framework instead of the one that you've carefully negotiated for your buyer client. So thanks again, everybody, for listening, for watching, for downloading this CLE presentation from the Tangible platform. Here are the instructions of how to obtain CLE credit for Oregon or for other jurisdictions accepting this CLE presentation for credit. If you have questions, please also just feel free to email the concierge at Tangible email on this slide.
And Alex and I want to thank everyone for their attendance at the session. And we really appreciate your time, and hope you'll join us for our next session on drafting and negotiating work orders and SOWs under the MPSA. Alex, any closing observations?
That's it. Thanks, Robert, and thanks to our producer, Robert Turnage. We will see you next time.
Thanks, everyone.